Greetings, 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 greetings. It is I, your King, King Clifford Jefferson, Senator Godfrey, the fifth Canavan Jew, son of Folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which was rich in spirits or descendants. I'm here today with another marvelous lesson to bring to you, my people, my subjects. It is September 8th, 2023, which in the Berber year is 2973. I greet you in the name of my queen, Sister Galveston, from the House of Galveston, as well as Archbishop Belmont from the House of Belmont, as well as all those who are members of the English Third Temple Church of England, better known as the Temple Church. All right, the English Third Temple English Church. I'm here with another marvelous lesson. I promise not to hold you all long, but we're going to pretty much leave the last two lectures in regards to the scriptures and go back to the law, because that's where we've seen Jesus at, arguing with the doctors of the law in Luke 2nd chapter, verse 49, and verse 50, verse 51. It's very important to come back off that because, Jesus was about his father's business. I'm about my father's business. Whether you look at it from the abstract or the concrete, I'm about my father's business. And I know that my father's descended down from other fathers, based off patrilineal descent. So there's a lot of people out there in the world that could be viewing this podcast, but unfortunately they're not, which is all right for me because it was chosen for a certain few. For those who are viewing this lesson, pretty much continue to stay on that straight and narrow path, which will bring you to fruition, that which knowledge, that which you seek. But once again, this lesson here today is pretty much to qualify what I've been saying since I started this platform in regards to the law. We know law is the common law, and the common law is a law that we should be used to, but apparently we're not. As a result of the metaphors that have been attached to us, as well as the laws governing those metaphors for those who that was placed upon. So a lot of us who have these platforms or starting platforms or having business or starting businesses, for whatever reason which you're undertaking, is really under the auspices of what we call paper wealth. Everybody wants to be wealthy, but going about it the wrong way, and 99.9% of the people who are acquiring wealth is going about it in a form of what they call the accumulation of what we call paper wealth. All right, paper wealth, paper money, or i.e. what we call the medium of exchange, which is considered today as lawful tender, and which is not. All right, you watch my previous classes on this matter. This one will be even fruitful than those that were brought forth by me. So without further ado, let's get started. All those which are listening caps on, please have them on. I know that there are no comments in the chat as well as online, which only tells me one thing, that either you agree with me, one, or two, you don't know what you're talking about, or three, those who are watching are of the certain few, or those societies or classifications that have some higher degree of understanding and interpretation about what's being said to them, excluding the metaphors, all right? Because they're the ones who created the metaphors in which we use to identify in regards to identifying with ourselves in society and that which we think of what's most beautiful and beneficial in society, which we call paper wealth, i.e. money, because you need money to be able to support your existence on this planet thing being manifested, i.e. your present societies, your communities. You need money, okay? And money is what assumes to accumulate what we call wealth. And wealth is considered that in what you buy with that money. All right. Wealth is considered that what you buy with that money. All right. Whether no matter what it is, it has to be purchased. All right. That falls under what we call trade and commerce, buying and selling. All right. From goods from one person to the other, the buyer, one who has use for the goods. And you find that in everyday life. All right. You find this in everyday life. All right. So pretty much what I'm trying to show you today, as I've been showing you on this platform, that I'm not concerned about paper wealth, nor am I teaching on itself. I'm not teaching about paper wealth, nor am I concerned about paper wealth, because I know based off knowing what money is, you can never gain wealth off that. You know what I'm saying? Especially wealth known as what we call real property. Okay, so I know I talk a lot, but for the sake of your salvation, it's my obligation to continue on my obligation which is about my father's business. All right, which is about my father's house. All right, now please watch the last two videos that I did, as well as every other video that I did. Please watch them because they're very informative, as well as not saying that your gifts are not needed for those who are able to contribute in lieu of a lawful medium of exchange. You can send your donations to $ Clifford Jefferson L, or you can send it to the English Director. My microphone video keeps going off. Microphone, give me. All right, so let's get started. Please follow along. I promise not to hold you long, okay? Now, if you're watching this video and you're not leaving any type of comment or anything to show that you comprehend what's being said, or if you disagree with this video, in regards to being said, then I know that your intentions for whatever you're doing is a result of what we call paper wealth. You are doing business, trading and commerce for the exact purpose of creating what they call paper wealth. Because outside paper wealth, you have no other wealth whatsoever. And I'm not just saying that from an abstract, I'm gonna prove it concrete, all right? Because the only antonym for paper wealth is what we call real wealth, all right? So paper wealth. Paper wealth means wealth as measured by a monetary value as reflected in price of assets. How much money one asset could be sold for. Paper wealth is contrast with real wealth, which refers to one actual physical asset. Once again, I repeat, paper wealth means wealth as measured by monetary value. Monetary value is the physical system that one used to fund whatever administrative government or whatever that's done in public or private. This is what you use to fund it. Paper wealth, which means a wealth as measured by monetary value, which is created by your government, as reflected in the price of assets. How much money one asset could be sold for. Paper wealth is contrast with real wealth, which refers to one's actual physical assets, all right? Physical assets, that which is tangible, all right? The paper wealth is not the asset, because the paper wealth is the medium of exchange to acquire what we call the asset. All right. The term paper wealth is frequently used in popular discussions of wealth and in some critics of capitalism, finance, and certain economic theories, but is little used in mainstream economics, which instead generally identifies wealth with paper wealth. The term paper wealth has some pejorative connotations, suggesting only on paper, but not in reality. Hence the word realty. All right. When brokers open up corporations to buy and sell property, is actually called a realty office. All right. But can also be used neutrally to mean simply as an accountable accounting matter. Relating distinctions are sometimes drawn between real assets and financial assets, or between tangible assets and intangible assets, the latter particularly in accounting as detailed below. Evaporation of paper wealth. Confusing aspect of paper wealth is that it can increase or decrease across an entire economy without any change to the real economy, i.e. real wealth. This is known as aspect prices called inflation or deflation, all right? A change in the aggregate nominal level of prices without corresponding real change. Thus, paper wealth does not come from or go to anywhere. The price just go up or down. Did you hear that? Thus, paper wealth does not come from or go to anywhere. It's created out of thin air. It comes from nothing. The prices just go up or down. It is a common misunderstanding to ask, where did the money go? All right, which is particularly asking in the case of stock market crash or in the bursting of price bubble. This has more colorfully been described as a lot of money goes to money heaven. All right, a lot of money goes to money heaven. All right, hence the word wildcat banking. Okay, wildcat banking. So everybody who think they got wealth in this paper, think twice. All right. Let's just revisit this in lieu of what we're talking about, paper wealth. Because paper wealth is not the proper medium of exchange. The proper medium of exchange is what we call gold and silver. Most businesses and most corporations main goal is for paper wealth. All right. This is why Jesus went to the temple and said, why have you turned my father's house to a house of a den of thieves? All right. With money exchanges. All right. The money that's supposed to be used is the lawful money that was used in the time of our ancestors, not that which is unlawful. And that which is unlawful is what we call paper money, which accumulates what we call paper wealth. John Sherman, the creator of the Anti-Sherman Act. As a senator, he was a leader in financial matters, helping to redesign the United States monetary system to meet the needs of a nation torn apart from civil war. All right. He also served as the chair of the Senate Agricultural Committee during his 32 years in the Senate. After the war, he worked to produce legislation that restored the nation's credit abroad and produced a stable gold-backed currency at home. The Anti-Sherman Act was enacted as a result of the people felt that paper currency, i.e. paper money, was part of cutting out. All right, hopefully it will stop. So everybody should look up the Anti-Sherman Act. Let's just go through that real quick. He returned to the Senate. Let me make sure you all see. He returned to the Senate after his term expired, serving there for a further 16 years. During that time, he continued his work on financial legislation, as well as writing and debating laws on immigration, business, competition laws, competition law, interstate commodity. All right, interstate commerce. For some reason, my screen just keep freezing or going off, so I'm just leave it off. All right, Sherman is the principal author of the Sherman Act, Antitrust Act, which was signed into law by President Benjamin Harrison in 1890. All right, 1890 is this is Sherman Antitrust Act. The Sherman Antitrust Act of 1890, see Title 26 Statute .209, as well as Title 15 of the United States Code, Section 1 through 7. Please review that statute. All right, please look up that statute. The Sherman Antitrust Act is the United States antitrust law which prescribes the rule of free competition among those engaged in commerce. It was passed by Congress in the name for Senator John Sherman and his principal author. All right. The Sherman Act broadly prohibits 1, anti-competitive agreements, and 2, unilateral conduct that monopolizes or attempts to monopolize the relevant market. The Act authorizes the Department of Justice to bring suits to enjoin, i.e. prohibit conduct violating the Act, and additionally authorize private parties injured by conduct violating the Act to bring suits for treble damages, 3 times as much money in damages as the violation cost them. Over time, the federal courts have developed a body of law under the Sherman Act, making certain types of anti-competitive conduct per se illegal, and subject other types of conduct to case-by-case analysis regarding whether the conduct unreasonably restrains trade. Okay, when you look up monopolies, it tells you that when gold was taken off the standard, that's the reason why the Anti-Sherman Act was actually created. All right, for those who hear me, please do further research on that. All right, so we know that as a result of paper wealth, which the citizens as well as those who cooperate as citizens being legal persons, the only way you can accumulate wealth is through paper wealth, because the only real wealth, which is contrast to that, is that wealth that belongs to the actual subjects of the crown. All right, which I'll prove today. So let's validate the antitrust law created by John Sherman in 1890, do what we call state versus person, case law, which we already talked about. Standard Oil Company of New Jersey versus United States, 1911. Standard Oil Company of New Jersey versus United States, 1911. The Standard Oil Company was created by the Rockefellers, all right, which we already was metaphor as a Frankenstein monster, okay? We talked about that in my last class. The term restraint of trade and attempts to monopolize, as used in the Antitrust Act, took their origin in the English took the origin in the common law, were familiar in the law of this country prior to and at the time of the adoption of the act, and their meaning should be sought for the conception of both English and American law prior to the passage of the act. So everyone thinks they have an understanding of what we call antitrust law, which is the law restraining of trade, which deals with monopoly. We know monopolies are given through charter, and the only way you get a charter is through the minority. The other method that is required is to register with the state. All right, registering with the state, and the state is not sovereign. All right, so when you say English, you're talking about the administrative government under the crown. When you talk about under the control of the minority. When you talk about American, you're talking about that was created under the Articles of Confederation, because the United States grew from the Articles of Confederation, which we'll discuss in a second. All right. The original doctrine that all contracts in restraint of trade were illegal was long since so modified in the interest of freedom of individuals to contract that the contract was valid if the resulting restraint was only partial in the operation, if it was not otherwise reasonable. Okay. The early struggle in England against the power to create monopolies resulted in establishing that those institutions were incompatible with the English Constitution. Everybody should understand that. The superiority. We're not talking abstract. So all those who can disagree with me, I can care less, you know, because the authority for monopoly comes from England as the measure that you have to measure up to. All right. At the common law, monopolies were unlawful because of their restriction upon the individual, i.e. subjects of England, freedom of contract, and their injury to the public in common law. And the contract created the same evils were brought within the prohibition as impeding the due course of or being a restraint on trade. So it was under our common law to actually do business and trade with lawful money, which was why the Anti-Sherman Act was created as a result of them opting out for the Speech Resumption Act, which was established in 1875 for the restoration of gold. All right, the restoration of gold. At the time of the passage of the Antitrust Act, the English rule was that the individual was free to contract, to abstain from contracting, and to exercise every reasonable right in regards thereto, except only as he was restricted from voluntarily and unreasonably or for wrongful purpose restraining his right to carry on his trade. This is what's being on today, because when you use paper wealth is a promissory note, all right, which is a promise, all right? When you agree by receiving promissory note as a redeemable instrument in regards to you be the holder in due course, then that's a violation of law. You're not supposed to do that. I didn't say that. The decision from the House of Lords says so. A decision of the House of Lords, although announced after an event, may serve reflexively to show the state of the law in England at the time of such event. This country has followed the line of development of the law of England, all right? Not the right to incorporate, do registration under the laws of what we call the states or the laws of the United States, because this case involves the United States in lieu of the registered corporation, i.e. Standard Oil Company, which the court has ruled is unlawful. It violates antitrust law. All right, it violates antitrust law, i.e. the law for the laws governing monopolies and the laws of the activity of the monopoly. This country has followed the line of development of the laws in England, and the public policy has been to prohibit or treat as illegal contracts or acts entered into with the intent to wrong the public, which unreasonably restrict competitive conditions, limit the rights of individuals, restrain the free flow of commerce, or bridge about the public evil, such as the enhancement of prices. Okay? The Antitrust Act of 1890 was enacted in light of the then existing practical conception of the law against the restraint of trade, and the intent on Congress was not to restrain the right to make and enforce contracts, whether resulting from combination or otherwise, which do not unduly restrain interstate or foreign commerce, but to protect the commerce from contracts or combinations by methods, whether old or new, which could constitute an interference with or an undue restraint upon it. All right, everybody needs to understand this. So the right to trade is a right for the individual, i.e. said persons which considered to be the heirs. All right, because we know that the monopolies were given by the charters of the crown, and the subjects that were given the charters to operate under the authority of the crown has to make sure that all finances goes to the crown of society that's protected by the crown, because this represents what we call the king's revenue. When there is no heirs on behalf of the crown of the land tenures and do what we call real wealth, because real wealth is called real estate, because all produce comes from the earth, or i.e. the ground, i.e. the soil, i.e. all the commodities. But when the authority to use the commodity, which is not yours, comes from under the authority of the state, is unlawfully done because it violates antitrust law. All right, how we know it? Let's go to another case. Standard state represented by the Attorney General Parsons versus the same Standard Oil Company, and this was argued in the Supreme Court in 1950. So the Standard Oil Company versus the United States was in 1911, and this is another case we visited in the 1950s. Okay, in regards to monopolies' rights to be able to do business in regards to trade with assets that don't belong to them. And like I said, their medium of exchange to acquire real assets is paper money. All right, which is a violation of antitrust law. All right, so the reason why you don't have a right to the property as a result of how you purchased the property, which was unlawful from the door, which I proven. All right, let's see. Section 296 of State versus Standard Oil Company. Under our law, the right to impose the bar of the statute of limitations to acts and contracts of this class in a vested property, which the law-making body may not abrogate or impair. It is fundamental that the denial of the remedy affects the substance of the right in a constitutional sense. This conception of the bar of the statute of limitation as a vested right of defense. One second. Okay. All right, let's see where we are. The conception of the bar of the statute of limitations as a vested right of defense beyond legislative impairment was not abrogated or modified by the Constitution of 1947. We had the Constitution of 1947, which was preceded by the Constitution of 1844, which was preceded by the Constitution of 1776, which was under the authority of what we call the common law, Article 22 and Article 23. All right, Article 22 and Article 23. Everybody who doubts that, please look it up. The pertinent provisions of the Constitution of 1844 were reenacted without substantial change, and this is to be presumed that their retention constitutes the adoption of the quality and meaning accorded to them by the long set of judicial constructions. See the case law provided. There is no substance to the contention that under the Constitution of 1947, the Street Act that was created under the statute of New Jersey, i.e. Title 14A, for what we call the corporations, which are the monopolies in which we are speaking of, which was created under the 1898 General Corporation Act. All right, I already spoke about that in prior lectures. If you don't remember, please go back and revisit those. There is no substance of contention that under the Constitution of 1947, the Street Act limits the operation of the statute of limitations, even to the point of divesting an accrued right of defense under its provision. The argument is that these statutes have lost all force and vitality upon the abrogation of the Constitution of 1844 and by the adoption of the Constitution of 1947, again came into the full force and effect simultaneously by virtue of their wholesale reenactment under paragraph 3 of the new Constitution. And so they must be read together and reconciled. reconciled, and therefore the Sheet Act is not subject in any manner to the statute of limitations. So all those think they got protection, no, you do not. But they are mere continuance of these statutes by the constitutional fiat, i.e. color on this, is not indicative of a purpose to abrogate vested rights to defenses permissible under the statute of limitations. There is no suggestion of the legislative design by the original enactment to renew the bar of the statute of limitations in review of the favor of the state, a debt or demanded that inter partes have lost its vitality by the operation of that statute. The Constitution of 1947 does not give the statute a radically different quality in meaning. You hear? Because the only meaning it should have is that which is of the radical title of the crown, which I'll go to in a second. Hold that thought. Right? So we're not talking about paper wealth. We're talking about real wealth. The real wealth that belongs to the heirs, i.e. the land and the real estate that sits upon the land. Because the only real wealth is what we call land. All right? Real estate, real. We know the difference between what's fake and what's real. We already know paper is fake. All right? So anything you pay for with that fake paper is considered a fake interest. All right, a fake interest. In the modern usage means present day. All right. We're not talking about what you thought it meant or what you assume it meant or what you wanted it to mean. It said in modern usage, it signifies the falling of property to the sovereign for want of an owner. All right. That's called interstate. Interstate. For all those who are claiming you got in the state that's paid for with this money, you don't have anything because you paid for it with fake money. All right. It's not real money. For all those who claim to have in the state based off that which was left to you in what we call a trust, that now is in the hands of what we call the state, which can only hold it what we call bond vacatindia as unclaimed property. The only way to regain that property is by way of being an heir, because the property is supposed to transfer by what we call statute of descent and dispensation, which I already proved to you, and I'm going to prove to you again. All right. And modern streets signifies the falling of property to the sovereign for want of an owner. So in modern day, the question becomes, who is the sovereign? Who is the sovereign? All right. Because under prescription, somebody could be claiming to be the sovereign and not really be the sovereign if it goes unattested. All right. Anybody know prescription? I already talked about this, but let's revisit it for those who forgot. Shh. So anybody who claims to have a right by way of trust under national law or international law, then you better listen to what's being said, because I'm going to prove to you that you don't. All right. Prescription. Give honor to my Archbishop once again for his faithfulness and his hard work. Prescription in international law is sovereignty transfer. The transfer of sovereignty. Did you hear that? The transfer of sovereignty of a territory by the open encroachment by new sovereigns upon the territory for a prolonged period of time, acting as the sovereign without protest of other contests by the original sovereign. It is analogous to the common law doctrine of easement by prescription by private real estate. So the real estate in the United States is handled by what we call a broker. And if you're a broker, you must have a license by the state to buy or sell real estate. It never said anything about owning, because you can't own it because you only own it by way of easement. And easement is a non-possessory right and property that don't belong to you, whether it's done by an act of de jure legislation or de facto legislation. If the de jure legislation violates the treaty, then it becomes de facto. All right, even if it's enacted by a lawful administration, as you see in these modern days. All right. Right. So prescription in international law is a transfer of sovereignty, which allows real estate to be transferred to somebody claiming to be the sovereign, which is a violation of the common law, because under the common law, the only person that can own that property is the sovereign, i.e. the monarch. Where was I at? Let's see. I think it was it. And modern usage signifies the fallen property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owners' whereabouts is unknown. Okay? If an owner of property, whether personal or real or private, what's called a real or personal property, if the owner is not around to make a claim to it, then it's either put up, you know what I'm saying, as by custodians and watched over or looked over, or it actually goes back to what we call the sovereign, which can either be United States under their eminent domain power or under regal power, under Jewish regalia, under what we call the crown. All right. But under the modern days, how they perceive escheatment, which is the ability to be able to take property that falls in interstate. It says under the common law of England, pursuant to the Constitution of 1776 of New Jersey. All right. And this court case still with a court case from New Jersey. It says that under the common law of England, escheats came to be classified as another branch of the king's ordinary revenue, which I stated earlier. It says that the doctrine of escheat at the earlier common law operative only upon that which was subject of tenure, since it's related to the reversionary right of the Lord to take for want of a tenant, i.e. Luke's Psalms 11:01, all right, Psalms 11:04, part self, was eventually extended to include personal property, tangible and intangible, all right? So that which you can see and that which you cannot see. Because intangible means you can't touch it. You know what I'm saying? So all those who claim to have an inheritance based off the abstract story going back to the Bible, your remedy is right here. All right. The principle is that the right to take that which belonged to no one was appertaining to the crown as jure regalia. This is done with the ascension of the succession of Jesus, i.e. Christ, as king, as in what we call the order of the Melchizedek. All right, to sit at the right hand of the Father. All right, under what we call patrilineal descent, agnatic succession. It says, for the crown steps in to take its own, the crown steps in to take the property because it is vacant. Property described as bona vacantia is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right and the exercise of the sovereign power. In personal estates, which are allodial by law, the king is last heir when there is no kin. You hear that? The king is last heir when there is no kin. Why? Because the land is automatically allodial under the crown. When it was given by way of what we call estates and land, it was under what they call finger simple, but it remained entail. It remains entail because the crown personifies entail land because it's called crown land. I already talked about that. I'm not going to go through it again. All right. So let's go through it. So you got 2 case laws to support this. All right. 2 case law. Let's go back to here. Martin versus Waddell. Another case law. I talked about this again in the last case, last lecture. All right, let's start right here. Martin versus Waddell. And I can discover nothing in the authorities, you hear that? In the authorities, giving in countenance to the idea that the king held the land covered by the waters of the navigable rivers as trustee, or by tenures different from that by which he had held the dry land. So all was allodial under the crown, under what they call radical title. All right, radical title. That which was on the navigational waters as well as dry land. All right, let's prove that under what we call radical title. How many people who claim to be students of how many students who claim to be students of teachers are being taught like this? Radical title. Radical title is make sure you see it. Radical title is a concept in English common law that refers to the crown's underlying title to all land held in overseas plantations and colonies. It grants the crown the power to take back others from the land and to transfer benefits and owners of the land to itself or others, but by itself does not grant beneficial ownership, right? Because it's already owned. So how could it grant something that's already owned? It's entail, it's hereditary, all right? Let's go back to Martin versus Waddell. And I must again repeat, if the king held such land as a trustee for the common benefit of all his subjects. It didn't say citizen, it didn't say Indian, it didn't say Negro, it didn't say black, because Negro, black are just metaphors denoting to the king's subjects, which are now classified as citizens, but does not fall under the classification of citizens according to the Naturalization Act of 1790. All right. All this needs to be considered. All right. I must again repeat that the king held such land as trustee for the common benefit of all his subjects and the inalienable as private property, i.e. allodial. I am unable to discover on what grounds the state of New Jersey, not just the state of New Jersey, but any monopoly allowed to register under the state of New Jersey under monopoly, because if you do, it violates antitrust law. All right. But the only reason why you were allowed to do so was a result of what we call paper wealth. And paper wealth, i.e. paper money, is also a violation of antitrust law, which is seen that in what we call the state versus Standard Oil Company, as well as we've seen it in represented by the attorney, state versus Attorney General represented by Parson, as well as the United States versus the Standard Oil Company. All right, we've seen it right there. Because the king held such land as trustee for the common benefit of all his subjects and inalienable as private property. And I'm unable to discover on what ground the state of New Jersey can hold the land and discharge of such trust and can assume to dispose of it to private and exclusive use of individuals. All right. So who all classify individuals, that still need to be specific. All right. If it was a trust estate in the king for the benefit of his subject, and upon the revolution, the government of New Jersey became the trustee in place of the king, and the trust developed upon such government, and the land became as inalienable in the government of New Jersey as in the hands of the king, and the state must be bound to hold all such land subject to the trust, which its contended as contended embraces a common right of fishery in the waters and the direction of oysters in the land covered by the water. If this be so, there certainly can be no power in the state without a breach of trust to deprive the citizens of New Jersey of such a common right and convert these oyster grounds to a private and exclusive use of individuals, i.e. corporations, i.e. so the corporation, citizens, the king's subjects, as well as the heirs are what's in question today. All right. So we all need to ask ourselves, who are we in regards to what's being qualified by case law? All right, which is nothing but a review of the rights governing the people who were subject to the common law, which was that use at that time. And the common uses don't need to be proven by what we call prescription if the mind of that common law doesn't run contrary to the uses in this modern day, which I'm showing you don't, because this is what we do. This is our law. All right, this ain't their law, this is our law. All right, let's prove it. Let's go through. All right, if the land held it in trust, let's go here. New Jersey Revised Statute. Because I said the state's transferred by statute of dispensation. We don't need a will. All right, you don't need a will. You just have to be an heir. When I say heir of my father's house, when I say my father's house, I say in the father's temple, because Jesus was found in his father's house, which was the temple, dealing with his father's business, which is, you want to call a corporation, fine, because I ain't incorporated. You know what I'm saying? Through my certificate or articles of incorporation, i.e. my charter, to personify or incarnate or represent what was all the kings who sat in that seat in lieu of the succession, i.e., which means to sit, all right, under the English usage, not abstract, but the concrete, all right, which I'm giving you now. All right, so feudal tenures, estates, and instances thereof taken away, discharged, and abolished from and after March 12, 1664 by Section 2 of an act entitled An Act Concerning Tenures, passed February 18, 1795, should so continue to be taken away, discharged, abolished, and no such state of any instance thereof shall at any time be created in the manner whatsoever. So if you got in a whole in your possession any type of land under the authority of some state or some corporation, which is the state, by authority of the state, do registry without a charter from the king, which we prove that the land belongs to the king, as proved by legislation as well as by case law, because case law going back the transfer of land, under allodial land, back to the crown, as seen here, because everything that was given by those kings to charges to those tenants in chief were recalled or revoked or taken back or taken away. How we know? Because we just read it here in the statute in 2022. All right, 1664. Everybody see that? What happened in 1664? Let's see. Y'all better do your research. March 12th, King Charles II of England makes a royal charter for the territory in North America that leases. Did you hear that? That leases, leasehold. You either got freehold or leasehold. Freehold and leasehold. That's not ownership, y'all. That's renting. But we just read under the statute 46.3-2 that lease was done. It's over. It says March 12th, as stated in the statute, King Charles II of England makes a royal charter for the territory of North America that leases to his brother James, Duke of York, a patent, i.e. a letter patent, for a large amount of land. It was in what is now the Northwest United States, according to the charter. James received all that part of the mainland of New England between New Scotland in America and the river of the Kennebec along the Mattawamkeag or Long Island, which are so-called Native American metaphors now, and Martin's Vineyard and Nantos, and the land between the Connecticut and Hudson River, and the land from the west side of the Connecticut and the east side, Delaware Bay. The lease, which includes the territory claimed by Dutch Republic as New Netherland, is for the most of the U.S. United States of Maine and part of the Connecticut, New York, New Jersey, and Pennsylvania. Did you hear that? It's a lease. It is a lease by the owner to the tenant. If you're the owner, that means that you're the landlord, and in the abstract story, the landlord is the owner, and the landlord is the son of what we call Jesus Christ, because Jesus was called Lord in Psalms 11:04. All right? In Psalms 11:04, as well as he fit the description as the Christ King to come back to take back the estate. Yes, New Jerusalem, a city in the clouds, right? Because every estate doesn't have a clear chain of title, it's called a cloudy title. A cloudy title, that's the actual legal term, everyone. All right. So I prove to you that all the land given by Charles II to from Charles II to Duke of York, it no longer belongs to Duke of York because the land is allodial. We proved it in New Jersey statute. We just read it. Let's continue. "13 colonies. The 13 colonies, also known as 13 British colonies or the 13 American colonies, were a group of British colonies of the Atlantic coast of North America found in the 17th and 18th century. The American Enlightenment led to the colonies to the American Revolutionary War. It declared independence as the United States of America in July 1776, which was achieved by the Treaty of Paris in 1783. The Treaty of Paris in 1783 was with great King George III, but there was prior treaties of Paris that were signed with the so-called 13 colonies under what they call the Articles of Confederation, right? And the 13 colonies and the parties that made up the 13 colonies were as included New England colonies, which include New Hampshire, Massachusetts, Rhode Island, Connecticut, the middle colonies, which include New York, New Jersey, Pennsylvania, and Delaware, and the southern colonies, which include Maryland, Virginia, North Carolina, South Carolina, which in particular, in Georgia, all right? The 13 colonies have very similar political, constitutional, legal systems dominated by Protestant English speakers, okay? So these colonies were dominated by Protestant English speakers. They weren't English, they just spoke English, all right? Which is what you speak in today, all right? So let's get down to it. Naturalization Act. I gotta keep talking about this until y'all get it down pat. Naturalization Act of 1790. This is still under the Articles of Confederation, as well as under the United States of America, because Article 6 is called the Engagement Clause. All treaties made before the adoption of this Constitution are supreme law of the land. All laws and treaties made before the adoption of this Constitution are the supreme law of the land as pursuant to the Articles of Confederation. So the United States is a metaphor for the Articles of Confederation. Once again, United States is a metaphor for the Articles of Confederation, which is nothing but a contract dealing with parties, and the parties were foreign to this land in lieu of ownership, because the ownership of the land was the king. All right. The Naturalization Act, as qualified by the statute, you all see it here, was a law of the United States Congress that set the first uniform rule of the granting of United States citizenship by naturalization, not nationalization. So if United States citizenship is based off nationalization, then how could you say that United States is a nation? How could you even say that? And if you're not a nation, then that means that you don't have no nationality. And nationality goes to a particular geography of that nation, i.e. that group of people, i.e. who makes up that society. But according to the United States and the minds of the framers of the people who made up the United States, i.e. individuals, the law of living naturalization to what we call free white persons of good character. This excluded Native Americans, indentured servants, enslaved people, free black people, and later Asians, although free black people were allowed citizens at the state level in many states. You hear that? At the state level, but not the state level as it was known under the Articles of Confederation. Before it became under the Articles of Confederation, because prior to the Articles of Confederation, it was running under the authority of the Crown. 1776, the province of New Jersey. All right, New Jersey, the province of New Jersey, look it up, Queen Anne. So if the Naturalization Act was based off the characteristics that was deemed based off the framers of those at the time of the society was created under the Naturalization Act of 1790, which is still the same people under the Articles of Confederation of 1778. Same people we talking about. They're just using names as they go along. All right. So if that is the case, then that brings me back to Enray, Ahmad versus Hassan. Why is this important? Because we know that the first requirement for establishing yourself to be deemed a part of a society, i.e. a group of people, based off characteristics, and characteristics may be different from each individual. But you have to prove that based off the characteristics of the individual claiming to be a part of that society, you must first prove the first test based off nationality. And nationality is not determined by the color of the skin. All right, and that goes for all colors. All right, I didn't say that. The district court judge Tello said that. Let's see. So all those who've seen the video last time, you watch this time, should have a better understanding, because it's all dealing with, as we said, what was it? The 13 colonies, right, which were corporations that incorporated, and the only way they can incorporate it to become what they call that corporation known as the 13 Confederate States, they needed financing. So that means they needed funding. And the only funding they can use was not the money that was used prior to that incorporation and that funding. It was that which was created, which was under paper wealth. And paper wealth is not considered real wealth, because the real wealth is what we call real estate. And the real estate is land. And they didn't own the land. They were not allowed on the land. They was only allowed to lease the land, as we proved in the charter given by Charles II on March 12th, 1664, which we see that under the statute of dispensation, those people that had the authority to use the land by prescription under the Prescription Act, which is licensed to use under what we call easement, was actually abolished. It was abolished, okay? So we understand that no person that's not an heir in lieu of that land being under allodial authority under what we call the crown, it being entail, has the right to be on that land. Because we just read that under the radical title of the crown has the right to alienate anybody that's on that land, i.e. those colonies, overseas possessions, all right? The overseas possessions, which are the 13 colonies, all right? It says to summarize the approach in regards to being subject, i.e. of the crown, misnomer as a British subject, because we know British is a result of the Naturalization Act, and the Naturalization Act was modeled after the Plantation Act of 1740. And we know that was modeled after the Treaty of Union. The Treaty of Union was a result of the amalgamation of foreigners into English on English land, because Scotland and England united with Scotland and Ireland united with England in 1707, which brought forth what we call the Naturalization Act of 1740 to allow them to settle here on English estates. All right, the land was allodial. So to qualify who have a right to the land, because as we read in the case law under Martin versus Waddell, that the king held the trust for his subjects. All right, but the subjects is not the same subjects that fell in the description under the Naturalization Act of 1790. Okay, and Black people didn't fall under the description of the Naturalization Act, nor whether they're free or not. So the only rights they had was that based off those rights were protected by England, and we know that because it said that under Stuart versus Somerset, which were Somerset versus Stuart, which we're reading quite quick in a second. So it says to summarize the approach which must be followed in deciding whether a particular person applying for citizenship, if you're a citizen, or if you're a subject of the king, or you're an alien, those are the three questions you better be asking yourself. Because to summarize the approach which every one of us must satisfy in deciding where which in lieu of applying for citizenship is a white person, because if you ain't a white person, you're a Black person. If you're a Black person, then whether you're white or Black, that's still not a proper citizenship, because it's not based off nationalities in regards to the citizenship who make up those nations. All right, very simple. All right, it is necessary to determine first the particular group or racial subdivision to which the individual belongs. And practical effects, proof of this fact is a matter of genealogy. Proof. All right, see it. Matter of genealogy. An individual who presents an aberration from a color of skin of a group of which he is a member, such as light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, it only gave you one example as a dark-skinned Anglo-Saxon, all right, does not thereby acquire a different status under the act from other members of his group. So if other members of the group identify Anglo-Saxon had a different complexion of skin color, you must first satisfy the first test, which is proven genealogy, and that comes under ethnicity. And Naturalization Act does not satisfy those two requirements, that first requirement. All right. And they know they had a nationality for the establishment of the Naturalization Act and the model act that came from the Naturalization Act of 1740. They had a nationality back then in 1740, but they threw it off in 1790, which is a violation of what we call the treason. That's a treasonous act. That's treason. That is an act of treason. All right, and we know that and under what's that law? Felony and treason are the reason for what we call bill of attaints. Bill of attaint or bill of attainers. All right. When you got a bill of attainers, that results in what we call escheatment. And we know that escheatment can only be done by the crown. If it's done under the United States, it's only based off them being custodian. All right. So In order for you to satisfy whatever characteristics in regards to try to classify as a part of a nation on some particular geographical area that they claim to be derived from, then you must satisfy genealogy test. All right, G. All right. It also says, where is it at? After the individual has traced into, if after the individual has been traced into his group, the second question which the court must answer is whether the member of the group as a whole are white persons, as Congress understood and the term in 1790 when it first enacted the statute. And deciding this latter question, the test is not how the group in question will be classified by ethnologists who have made a study of racial origin, but rather the groups of people then living in 1790. So whoever you was prior to 1790, they're not concerned about it. So if you agree with the concept in 1790 and not concerned about or who these people were prior to that, then you are in a world of trouble. Applying these principles, the court finds that petitioner is an Arab, and the Arabs are not white person within the meaning of the act. Okay, so the Naturalization Act has no standing in regard to any claim on right to property. All right, because you don't own the property, right? Because who are you to have the right to own the property? You only fall under what we call, as I said, prescription act. All right, so we know that white people don't fall under the first requirement, genealogy. Black people don't fall under that test dealing with genealogy, as well as Indians. Because Indian is not a genealogy, it's just a classification. But we're not concerned about genealogy, we're only concerned about those native to this land, because Native American and Native Indian are two classifications. All right, and I'm saying that Anglo-Saxons who were dark-skinned are natives to this land. Who were dark-skinned, for the lack of a better description, were us. All right, and that was Dred Scott's problem. All right, let's see Dred Scott's. Dred Scott versus Sanford, 1857. Was a landmark decision of the United States Supreme Court that held that the United States Constitution did not extend American citizenship to people of Black descent, and thus they could not enjoy the rights and privileges the Constitution conferred upon American citizens. You all better listen. The decision was considered the worst in the Supreme Court history, being widely denounced for its overt racism, perceived judicial activism, poor legal reasoning, and crucial role in the start of the American Civil War 4 years later. Legal scholar Bernard Schwartz said that it stands first in any list of worst Supreme Court decisions. Chief Justice Charles Evans Hughes called the court greatest self-inflicted wound. All right, so you are contented to be subject to the wounds caused by slavery if you still decide your standing based off slavery, which was decided by those who put you in slavery, as in the case of Dred Scott. Why? Because if Dred Scott would have knew that he was an English descendant, he would not have been in that position. How I know that? Let's look at Somerset versus Stewart. Here. The reason why Dred Scott can be free because he was a slave of the House of Stuart, i.e. King James, right? Because citizenship was only referred to the Naturalization Act, but came from the Plantation Act, the National Act of 1740, all right? King James at the time, Dred Scott at the time was was emancipated to 1865, but he still was not classified to be a citizen under the Naturalization Act of 1790, because the Naturalization Act of 1790 was only for the class of the classification that resulted by those classifying as free white person denying their nationality and claiming a new identity under what they call free white person. All right. It says here, Somerset versus Stewart. This is by the King's Bench. Somerset versus Stewart, known as Somerset versus Stewart case in Mansfield's judgment, is a judgment of the English courts. So if you're in the English court, you got protection. But if you're not in the English court, you don't have protection. So that means that these courts that you have now are not English courts. They should be, but they are not. Why? Because they're saying ain't no English people around. All right. On the New Jersey versus New York Supreme Court case, they said that the Supreme Court had to make alterations for the King's Bench when it comes to acquiring the title and know what we call a Bill of Peace. New Jersey versus New York. All right, look that case up. All right, so it says in that case, the court of the King's Bench in 1772 related the right of an enslaved person on English soil not to be forcibly removed from the country and sent to Jamaica for sale. All right, as what? A commodity. As a commodity. I read this case the other day. The state of slavery is of such a nature that it is capable of being introduced on any reason, moral or political, but only by positive law, which preserves its force long after the reason, occasion, and time itself from which it was created. It is erased from memory. It is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences therefore may follow from the decision, I cannot say this case is allowed or approved by the law of England, and therefore the blacks must be discharged. That's why you could not be a citizen under the Plantation Act of Naturalization Act of 1740, which modeled the Naturalization Act of 1790. All right, they said it in 1790. Right here. Congress modeled the Naturalization Act of 1790 off of the Plantation Act of 1740. Under King George II, that was officially titled an act to naturalize such foreign Protestants and others therein mentioned as are settled or should settle in His Majesty's colonies in America, and using provisions concerning time, oath of allegiance, the process of swearing before a judge. Aren't you reading this from a court case? Yeah. 1790, you're reading it in the Dred Scott case. But under King's Bench, you said that you were protected. But under Chief Justice Taney, it said that you wasn't protected. All right. Chief Justice Taney also said it in case law in regards to the king's property, that all property, no matter if it was slaves, belonged to the king. So if you were enslaved by the kings under the British monarch, the only way you could be free from slavery is that by the kings of England, as qualified by the King's Bench. All right. So the Naturalization Act that was created by the framers of the Constitution for those who call themselves American citizens, and under the Articles of Confederation, derived from what we call the Naturalization Act of 1740. Let's review that real quick. Plantation Act of 1740. Referring to the colonies of the Naturalized Act of 1740 are common names, i.e. metaphors, used for an act of the British Parliament that was officially titled an act for naturalizing such foreign Protestants and others there mentioned as are settled and should have settled in His Majesty's colonies in America. The act became effective on June 1st, 1740, and allowed any Protestant alien, i.e. the Naturalization Act, i.e. naturalization, because naturalization is the only process from which the alien can become a citizen. The only process for becoming a citizen under the jure way is through nationalization, all right? And naturalization can only be done by a nation. And the 1740 Act, no other Naturalization Act of 1790 was done on behalf of a nation, all right? If it was a foreign nation, as you can see. So if you are American colony and American citizens, then you are a foreigner here in America. Let's continue. And that resulted from the Acts of Union. The Plantation Act, Naturalization Act of 1740, as well as 1790, resulted from the Acts of Union in 1707. And the Acts of Union was a result of England and Ireland and Scotland uniting with the Kingdom of England. So don't get it twisted. Just because they united, that don't mean that it was done lawfully. All right? Don't mean it was done lawfully. It was done by breaking ties of the family, going back to what we call trefoil and unknotted. Our family is in a knot now. We tied up. We don't know who's who. All right? We don't know who's who. The Act of Union was two acts of Parliament of the Union with Scotland Act of 1706 passed by the Parliament of England and the Union of England Act passed in 1707 passed by the Parliament of Scotland. All right? They put into effect the terms of the Treaty of Union that had been agreed on the 22nd of July in 1706, following negotiations between commissioners representing the Parliament of the two countries. By the acts, the Kingdom of England and the Kingdom of Scotland, which at the time were separate states in the personal union, were, in words of the treaty, united into one kingdom by the name of Great Britain. Did you hear that? Great Britain. They were separate states. All right? State is just a polity. But we know that the states that were created were confederate states, not what we call what's that term? Sovereign state is what's the term called? It's just my mind. You have a confederate state, the federal state, and what's the other term? It's just my mind. Forgive me. I got a brain freeze on that. But let me continue. Article 6, the engagement clause. Article 6 of the United States Constitution. Article 6 of the United States Constitution establishes the laws and treaties of the United States made in accordance with it as the supreme law of the land, forbids a religious test as required for holding governmental position, and holds the United States under the Constitution responsible for all debts incurred by the United States under the Articles of Confederation. All right? All debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under the Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made of which shall be made under the authority of the United States to be the supreme law of the land, that the judges in every state shall be bound thereby. Anything to the Constitution or laws of any state to the contrary notwithstanding. Remember, we're not talking about, they're not sovereigns on this land because they themselves is not a nation. So how could their laws have any effect? The only effect that they had is the dependency that they had on that which gave them authority to create this their constitution, which within that clause created the contract clause, and the contract clause is called the engagement clause, which you're reading now, which confines the senators, representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath of affirmation to support this Constitution, but no religious test shall ever be required as a qualification in the office or public trust of the United States. So why? Because under the Articles of Confederation, there was no executive judicial branch. All there was the legislature, and the legislature was that of Parliament. The first clause of Article 1 provides debt contracts prior to the adoption of the Constitution remains valid as under the Articles of the Confederation. Why? Because the engagement clause. What is the engagement clause? What is the precursor for the engagement clause? The precursor for the engagement clause under the Articles of Confederation is 12th Article of Confederation, was also the clause committed to the Confederation to honor promises made by the Continental Congress before the Congress, the Confederation convened, meaning that all continents before they even got together to create their ideological government. It stated that all bills of credit emitted, monies borrowed, and debts contracted before or under the authority of Congress before the assembling of the United States in pursuance of the present Confederation should be deemed and considered as a charge against the United States for payments satisfaction whereof the said United States in the public faith are hereby solemnly pledged. So that brings up the contract, the Jay Treaty, and the Articles of Confederation. The Jay Treaty and the Articles of Confederation, which are the supreme law of the land. All right, so let's visit that. And by the way, just to show y'all, indeed, we are the English Anglo-Saxon Berbers. The history of the name Berber begins with the Anglo-Saxon tribes, i.e. the 12 tribes, and is derived from the baptismal, i.e. Being baptized in the church, all right, meaning son of Barbara. And in some instance, the name may have also been a nickname for someone such as a Moor or Berber who appeared to be of North African heritage. In such a case, name is referred to the Barbary coast of North Africa. Okay? Everybody see that? Everybody sees that. House of names. So if you call yourself a Berber, you better be a part of my father's house. And the origin of the name was first found in London. You hear that? Now, if that's the case, let's go here. If we call ourselves the Plantagenet Crown, and the Plantagenet Crown were the ones who considered themselves the planters, because a planter plants, and the word planter and plants had the same family crest. Just look up planter. Okay, England. The ancestors of the planters family brought their name to England and the wave of migration after Norman conquest in 1066. The name planter is from the gardener, i.e. gardener, planter, you know what I'm saying? Was originally derived from the Old English word plant, meaning plant or young tree. The surname planter was first found in London, where they held a family seat being descendants from folk, i.e. kinfolks, i.e. You are the person identified as humans, as well as jailmen, as a result of you being subject to the conditions of the ignorance of who you were as a result of being descendants of the Plantagenet Crown, who ruled Jerusalem, which were the angels, the Anglo-Saxons, i.e. the living entity. We know human, as defined in the Black Law Dictionary, is what we call Yale men. And we know Yale man and human under the family crest of arms has a broken spear, but folk doesn't. The spear he's holding up is unbroken, and they both the line from folk. All right, and we know folk were the Jerusalem of Jerusalem. And when you look up the word heaven, and the word heaven shows you the family crest coat of arm of what they call an anchor. And you look up the word John, I mean, if you look up the word house, the family crest of the family crest coat of arm house is an anchor with a cloud on it. You know what I'm saying? Which was synonymous of the word John. All right, and we know John was the disciple of so-called Jesus. You know, so we have to understand understand the metaphor interpretation as well as the concrete interpretation of what we're talking about. All right, let's see. That takes me here. So we know the situation with Dred Scott position as a result of him not understanding who he was, because he wasn't subject to naturalization law. He was subject to naturalization law, which came to the laws that were allowed from the minor through the Naturalization Act of 1740, which was a result of uniting with the English houses in 1740 by the Union of the Crown. Prior to that, Dred Scott couldn't have no protection, because if he forgot who he was under the English protection, as decided in the King's Bench under Somerset versus Stuart. All right. Under Somerset versus Stuart, Dred Scott should have been classified by way of the first step genealogy as an English heir. All right. So let's go here. So under the engagement clause under Article 6 of the Constitution, all treaties are the supreme law of the land. All right. All treaties are the supreme law of the land. But some treaties are active, some treaties are not active. So let's see which ones are active before we can qualify. Once again, honest to Archbishop Belmont. We're not concerned about treaties of commerce dealing with commerce. We're dealing with treaties dealing with peace. All right? Because if the commerce and commerce that evolved from the treaties are done in peace, there's no violation of antitrust law. If the commerce is done in violation of the peace, then there's a violation of antitrust law. All the commerce done on this land is a violation of peace, because under antitrust law, the only commerce in lieu of lawful commerce must be done with lawful medium of exchange, which is gold and silver, which is protected under the antitrust law created by John Sherman. All right. So as you can see here, peace, the Treaty of Amity, Commerce, and the navigations between the United States and Great Britain under the Jay Treaty, signed in London, November 19, 1794, entered into force October 28, 1795. Only Articles 3, so far as it relates to the right of the Indians to pass across the borders, and Article 9 and 10 appear to remain in force. See Atkins versus United States, 1977. So here is Atkins versus United States. Atkins versus United States. It says here, on July 1694, the appellant carried a pair of hiking boots, which he had purchased in Canada, into the United States at the Calais main border station. A custom official assessed a duty of $1.20 on the appellant's boots, pursuant to the item's $700.45 tariff schedule of the United States. As the Penobscot Indians, Atkins claimed an exemption under Article 3 of the Treaty of Amity and Commerce and Navigation with His Britannic Majesty, November 19, 1794, commonly known as the Jay Treaty, from paying customs duties on goods for his personal use. All right, so that was the case law done with in regards to ability to be able to do trade and commerce across borders. All right, That falls under what we call interstate commodity. Everybody who's new, look up the word interstate commodity. Interstate commodity, or the laws of commodity. All right. So under the Jay Treaty, which was the Treaty of Commerce and Amity with the Britannic Majesty of Great Britain. So let's look that up. Now remember the Treaty of Paris of 1783. 1783, when all the land was given, that the United States were declared to be not a sovereign, but an independent nation to do trade and commerce under the Amity and Commerce Clause. All right, that's the only reason why they got the independence. I'm not just telling you that, I'm going to show you that. The Treaty of Amity and Commerce was the navigational between His Britannic Majesty and the United States of America, commonly known as the Jay Treaty, is also the Jay Treaty, and also as the Jay Treaty was a 1794 treaty between the United States and Great Britain that averted war, resolved issues remaining since the Treaty of Paris of 1783. Did you hear that? Which ended the American Revolutionary War. It facilitated 10 years of peaceful trade between the United States and Britain in the midst of the French Revolutionary War, i.e. the Treaty of Alliance. All right, because the French was mad with Great Britain. Great Britain was that mad with the colonies, and French assisted the colonies in their emancipation from Great Britain. All right, so this is treasonous act on behalf of the United States, i.e. the 13 colonies, on both parties. On both parties. All right, let's see. And facilitate a 10-year peaceful trade between the United States and Britain in the midst of the French Revolutionary War, which began in 1792. The treaty was designed by Alexander Hamilton and supported by President George Washington. It angered France and bitterly divided Americans. It inflamed the new growth of two opposing parties in every state, the pro-treaty Federalists and the anti-treaty Jefferson Republicans. Did you hear that? This treaty angered France. Why did it anger France? Because of this treaty. Treaty of Alliance, also known as the Franco-Alliance Treaty, was a defensive alliance between Kingdom of France and the United States, formed amid the American Revolutionary War with Great Britain. So it didn't say a defensive alliance between the Kingdom of France and Great Britain. It said a defensive alliance between Kingdom of France and the United States. The United States was at war with Great Britain. So how could you make a Jay Treaty with Great Britain when you already had a treaty with France? All right? We got to ask ourselves this. Most of it's not being taught. It was signed by delegates of King Louis XVI and the Second Continental Congress in Paris on February 6, 1778, along with the Treaty of Amity and Commerce and a secret clause providing for the entry of other European allies. Together, these instruments, also sometimes known as the Franco-American Alliance or the Treaty of Alliance, the agreement marked the official entry of the United States on the world stage and formalized French recognition to support United States independence that was to be decisive in America's victory. Did you hear that? The Treaty of Alliance was signed immediately after the Treaty of Amity of Commerce, in which France was the first nation to formally recognize the United States as a sovereign nation. This treaty had also established mutual commercial navigational rights between the two nations and direct defiance of British Navigational Act, which restricted American access to foreign markets. It's contemplation that these commercial and diplomatic ties would result in hostility between France and Britain. The Treaty of Alliance guaranteed French military support in just such an event. It also forbade either nation from making a separate peace with Britain and was contemplated as a permanent defensive pact. Somebody's in trouble. Somebody's in trouble. If this information has been here all this time, how come I, as King of England, was able to bring this information out? Right? Not bring it out, but make it applicable in the present day. All right? That's very important. Why do I say that? Let's go ahead. Let's do it with the J Treaty first. Article 9. Now, we know under the Nationalization Act and the 1740 Act by the Crown as well as the United States under the mind frame of the so-called British Crown and the 13 colonies in regards to their newfound freedom, their newfound salvation, which they call sovereignty, which did not include those under, as we've seen in Enray versus Enray Hassan, what was the name? Enray Ramah Hassan, which did not satisfy the second requirement in regards to the framers' minds in regards to the right to fall as a citizen under the Nationalization Act of 1790. But he fit the requirement of the first proof test in regards to citizenship of a nation as an Arab. All right. So if us as Misnama, as Negro, blacks, colors, whether we were free or enslaved, doesn't satisfy under the protection of the National Act of 1790, nor under the National Act of 1740, which was under the monarch. But we see in Somerset versus Stewart that black people were protected once we stepped foot on the soil under England. That shows that the British monarch were now operating under the authority of the Crown of England. It was under the authority of the British monarch, which was the subverted power under what we call Prescription Act or Prescription of Sovereignty. All right. And if that was the case, then this brings up Article 9, which says it is agreed upon in the Jay Treaty of 1975 that British subjects who now hold lands, they ain't talking about the free white persons, because they're not citizens, they're not subjects of the Crown, they're now American citizens. Not even talking about Indians, because we know that Indians under the Somerset versus Stewart, it limited the rights of the native Indians. All right. And we know that that within itself was based off of a lease given to the 13 colonies. All right. So it said it is agreed that the British subjects who now hold leases to the land and the territories of the United States and the American citizens who now hold leases to the land and the dominions of His Majesty should continue to hold them according to the nature and the tenure of their respective estates and titles therein, and may grant, sell, or devise the same to whom they please in like manner as if they were natives. Okay, so we know that under 46:3-1, when all the charges given by Charles II, the Duke of York, were recalled and now back under authority of the original grantor, i.e. the Crown, that means that the only person who has the right to the land is those who were heirs, because the land was held in the trust as established by Martin versus Waddell. All right, we proved that. So all lands here in North America only belongs to heirs, not free white persons, not citizens who are naturalized, nor Native American Indians. All right. Article 10. Neither debt due from individuals of one nation to individuals of the other, nor shares nor money which they may have in the public funds or any public or private bank shall ever in any event of war or national differences be sequestered or confiscated. If being unjust and impolitic, that debt and engagement contracted and made by individuals having confidence in each other and in their respective governments should ever be destroyed or impairment by national authority on account of the national differences and discontent. Article 11. It is agreed between His Majesty the United States of America that there should be reciprocal entirety, perfect liberty, and navigational navigation and commerce between the respective people in the manner under the limitations and on the conditions specified in the following articles. Did you hear that? Did y'all hear that? Okay, so if that's the case, the 13 colonies, which North Carolina was one of them, was a result of the monopolies who usurped the rights of the subjects under the authority of the English crown, which was usurped by the British crown as a result of the Treaty of Union in 1707, and then allowed those citizens, i.e., now subjects, as assumed, to take the right of Englishmen, you know what I'm saying, being that they're not Englishmen, because they are actually the colonies who are allowed to colonize North America as subjects of what we call the British crown, i.e. Irish and Scottish kings, all right? But not English kings, because the land was reserved for the English king as reserved by the case law. It said nothing about their British crown, Scottish crown, or the Irish crown, which are one and the same. It said the English crown. How we know? Because if you see on the New Jersey Revised Statute 46.3-2, which will go here. Says here, certain tenures and holdings turn to free common focus. Those holdings they're talking about the same one that you read in 46.3-1 in regards to the charges given by Charles II of New York, which were abolished. So it was abolished under the laws of the king, whether it was by the King of England or any other person or body of politics, corporate through incorporation, by way of what we call a corporation soul, and what we call the ascension or the succession of what we call Christ through incorporation or incarnation or personification. All right. The tenures and honors, manors, lands, tenements of hereditament, i.e., birthright, or of estates of inheritance at the common law held either of the King of England, and then say King of Scotland, King of Ireland, or the King of Britain. It didn't say that. It said the King of England. It was specific. Or of any other person of the King of England, i.e. an heir, or a body of politics, i.e. administrative government, or a corporation, because the only way you can become a corporation is by incorporating, and the incorporating government was authorized by the monopoly, because we know that the king's government was an itinerant government, which means that it was always moving. And at the time before July 4th, 1776. All right. We know when the United States, the New Jersey declared their independence under their Constitution of July 7, 1776, it was still under the authority of the common law, as Articles 22 states. And the reconciliation of Great Britain under Article 23 of the Constitution was a result of if the conflicts were dissolved. And as you can see, these conflicts were dissolved because the king had incorporated. All right. So that brings me here. Let's see, Treaty of Alliance. Okay. All right, right here. Article 9. The contracting parties declare that being resolved to fulfill each of its own part, the clause and conditions of the present treaty of alliance according to its own power and circumstances, there should be no after claim of compensation on one side. Article 10. Thank you. I'm freezing. The most Christian king in the United States agreed to invite or admit other parties who may have received injuries from England to make common cause with them and to accede to the present alliance under such conditions as shall be freely agreed to settle between all the parties. Article 11. The two parties guarantee mutually from the present time and forever against all other powers, to wit, with the United States, to His Most Christian Majesty, the present possession of the crown of France and America. You hear that? So not only the crown of France has authority over here, but the crown of the crown of England, which are actually one under the Plantagenet crown, as well as those which it may acquire by the future treaty of peace, and His Most Christian Majesty's guarantee on his part to the United States, their liberty, sovereignty, and independence, absolute and unlimited, as well as the matters of government, as commerce, and also their possession, and the addition or conquest that their confederation may obtain during the war from any of the dominions now or hereto possessed by Great Britain and North America, comfortable to the 5th and 6th article above written, and hold as their possessions to be fixed in the shore of the said state at the moment of cessation of their present war with England. So France was at war with England as a result of the Plantagenet Wars, all right? The Capitan and Plantagenet Wars. So all the land that belongs to America through the wars of the Plantagenet and the Capitan Wars, i.e. French, is the authority that we now have under the laws of the land, i.e. supreme law of the land, i.e. treaties, all right? So in closing, I bring you here to the North Carolina Negro laws, because we know North Carolina was one of the 13 colonies, all right, and which the Articles of Confederation to note to. Section 3. Indians and descendants of Indians are regarded as free Indians and amity with this government until the contrary be shown. It is declared that every Negro, Indian, mulatto, and mestizo is a slave unless the contrary can be made to appear. Yet it is immediately thereafter provided the Indian in amity with this government, excepted in which case the burden of proof shall lie on the defendant. That is, on the person claiming the Indian plaintiff to be a slave. This latter clause of the provision is now regarded as the furnishing rule. The race of slave Indians or Indians not in amity to this government. The state is extinct, and hence the previous part of the provision had no application. Section 4. The term Negro is confined to slave Africans, i.e., if Negroes, i.e. enslaved Africans, cannot be considered under the Naturalization Act, right, as well as the Naturalization Act of 1740, right? But we know under the King's Bench and Somerset v. Stewart that if slave, Negro, black, whatever you call you step foot in England, he's free, right? And we know Dred Scott, if he would have knew that he would be free in England, then he should have researched history prior to those monarchs claiming to be monarchs of England, i.e. the House of Stuarts, and all those who claimed the authority on the House of Stuarts, which were not English monarchs, they were actually Scottish and Irish monarchs. So as a result of that, those who came up under the status as naturalization under the Naturalization Act or Alien Act or what they call the Naturalization Act or Alien Act, Section 4 applies to you. The term Negro is confined to slave Africans, the ancient Berbers, and their descendants. It does not embrace free inhabitants of Africa, such as the Egyptian, Moors, or the Negro Asiatics, such as Lascars. I'm going to read it again. The term Negro is confined to slave Africans, the ancient Berbers. So the misnomer slave Africans is really the classification under the juror and genealogical and ethnicity test of the ancient Berbers, which automatically falls under Anglo-Saxons. And as you can see, you see the fleur-de-lis inside the family crescent coat of arms. So in closing, Section 5 says mulatto is the issue of whites and the Negro. Section 6, when the mulatto seizes and a party bearing some slight taint of African blood ranks as white is a question for the solution of a jury, which was the case in Enway versus Enway Ahmad Hassan, as well as in the case of Dred Scott versus Sanford, which must be decided based off the evidentiary proof. And none of them can meet that proof based off of skin color. All right? You have to show your relationship to your genealogy and ethnicity. And as they said, those who didn't classify as free white persons were enslaved or free Black people. And we know free or enslaved Black people were classified, as we see here in the Negro law, as Berbers. All right? So Section 7 says, whenever an African tainted is so far removed that upon inspection, a party may be fairly pronounced to be white, and such has been his or her previous reception into society. And enjoyment of the privileges usually enjoyed by white people, the jury may rate and regard that party as white. So if you don't fall in the classification of white person, you ain't on the same level as white person, which does not take in account of any laws governing the rights of those of nations of people, which is governed by international law, i.e. the law governing treaties. Section 8, no specific rule as to the quantity of Negro blood which will compel a jury to find one to be a mulatto has ever been adopted. Between 1/4 and 1/8 seems fairly to be debatable ground. When the blood is reduced to or below 1/8, the jury ought always to find the party white. When the blood is 1/4 more African, the jury must find the party to be mulatto. Section 9, the question of color and of course of case arises in various ways and may in some cases be decided without the intervention of a jury, which is the result of what we call attaints. Bill of attaints, because you committed treason by breaking your allegiance to who you really come down to be as Anglo-Saxon Berbers. And as when a party is convicted and brought up for sentencing or witnesses on the stand objected to a free Negro, mulatto, or mestizo, in these cases, if a color be so obvious that there can be no mistake about it, the judge may refuse to sentence or may exclude the witness. So if the party against whose color decision may be made should claim to have the question tried by a jury, it must, I apprehend, be so tried. All right. So with that, you have it right there, concrete proof to prove you're a citizen and or a subject or a slave. You must fit all the qualifications and all the measures and all the standards that have been set forth in this lecture. And for all those who assume that they are not citizens, you still must follow that same regard. Because if you don't, you're still going to be put in the same status as a slave. So with that, I say peace, and I greet you in the name of peace, as all my ancestors did, specifically Jesus Christ, King Edgar the Peaceful. Peace.